Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. Pursuant to notice, I now call up H.R. 68 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 68, to amend the Omnibus Crime Control Act and Safe Streets Act of 1968 to enhance the use of juvenile accountability block grants for programs to prevent and address occurrences of bullying and to reauthorize the Juvenile Accountability Block Grants Program.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. The committee's Criminal Justice Reform Initiative seeks to address a number of issues, including juvenile justice reform. We continue forward with our efforts today with consideration of H.R. 68, the Juvenile Accountability Block Grant Reauthorization, and the Bullying Prevention and Intervention Act. This bill reauthorizes the Justice Department's Juvenile Accountability Block Grant Program and strengthens the JBAG program to reduce youth crime and contains a robust accountability and oversight mechanism to ensure taxpayer dollars are used efficiently and appropriately. I want to thank the sponsor of this legislation, Congresswoman Jackson Lee, for her dedication and hard work on this issue. Crimes committed by our nation's youth strike at the very core of our communities. Our children are the promise of a bright future and our hope for continued prosperity. Reducing juvenile crimes and improving the juvenile justice system is a vital step to preserving and protecting the future of our children. The JBAG program provides grants to states, tribes, and localities to strengthen their juvenile justice systems and reduce recidivist behavior. The program currently has 17 authorized purpose areas, including the implementation of graduated sanctions for juveniles, support for prosecutorial initiatives aimed at curbing drug use, violence, and gangs, accountability-based school safety initiatives, the establishment of juvenile drug courts, and bullying and cyberbullying prevention. The JBAG program was most recently reauthorized in 2005, and despite JBAG currently being unauthorized, this bipartisan program continued to receive funding through 2013. JBAG received appropriations most recently in fiscal year 2013 when it received $25 million. The JBAG program has a long history of bipartisan support among members of the Judiciary Committee. A reauthorization of this program will send a clear message to our colleagues on the Appropriations Committee that we support reinstating funding for this program. And again, I thank my colleague, Congresswoman Jackson Lee, for her work on this issue, and I urge my colleagues to support this bill. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, I support H.R. 68, which would reauthorize and update the Juvenile Accountability Block Grant Program. It's an important part of the comprehensive effort to help states improve and operate their juvenile justice systems. I commend particularly our ranking member of the Subcommittee on Crime, Sheila Jackson Lee, for her work on this important bill and her steadfast desire to reform the ways our criminal justice system treats young offenders. In the late 1990s, fears about the prospects of a wave of juvenile crime, which turned out to be unfounded, inspired some legislators to call for harsher penalties for juvenile offenders. Instead, this committee, in a bipartisan fashion, worked to develop a program to help states take a more measured approach. That was the genesis of the Juvenile Accountability Incentive Block Grant Program, as it was originally named, and which was enacted in 1997. This program encourages the use of accountability models that hold juveniles responsible for their behavior by imposing consequences commensurate with the seriousness of the offense and the youth's prior criminal history, if any. In other words, it's fair and more effective from the standpoint of public safety. to not impose an overly harsh and disproportionate sentence on a young offender who has little or no history of prior offenses. And so that's why this committee has a history of bipartisan support for the Juvenile Accountability Block Grant Program. Although the authorization for the program expired several years ago, it deserves to be reauthorized, and our continued support is one of the ways the federal government provides assistance and guidance to states on their juvenile justice systems. This program fits within a framework of other initiatives targeting specific issues in order to support these systems and safeguard the rights of young offenders. And there are other steps we must take even as we work to reauthorize this worthy program today. And to this end, I remain committed to working with the chairman of this committee and every member on it to strengthen our common interests in ensuring appropriate treatment of young offenders. H.R. 68 is an important contribution to achieving this critical goal. And so I urge my colleagues to join with us in supporting this bill. Mr. Chairman, I thank you and yield back the balance of my time.
The chair thanks the gentleman and recognizes the sponsor of the legislation, the gentlewoman from Texas, Ms. Jackson Lee, for her opening statement.
Chairman, thank you so very much, and let me thank the ranking member as well. Take just a moment to acknowledge an officer who died in the line of duty in my district in a motorcycle crash. Just wanted to acknowledge that and recognize, of course, the memorial that I attended yesterday for the officers in Dallas, Texas. Thank all of my colleagues for their support and prayers. This is an opportunity again for this committee to show itself as one of the most important lawmaking committees in the United States Congress, truly impacting lives and certainly lives of young people. So my appreciation is to Mr. Goodlatte, Mr. Conyers, for your continued engagement and support, and to each and every member of the committee, Republicans and Democrats, who have given, in essence, their consent to this as we move forward and the vision that we have for reforming the juvenile justice system. This is an important step secondarily because we're looking at juvenile justice in a more innovative and, if I might say, right-standing way. And the federal government does have an essential role in the administration of juvenile justice and the overall effectiveness of juvenile justice systems. Reason being that these block grants impact state, local, and tribal levels. When coupled with state, local, and private funding, federal investments seed and support the development, implementation, sustainability of best practices in juvenile justice and delinquency prevention systems. We have not reauthorized this, as the chairman said, for a very long time. Doing this now puts the Judiciary Committee's stamp on what juvenile justice should look like. This JBIG funding has fulfilled much needed funding for states and localities that lack sufficient resources. Revisiting the need for reauthorization necessarily involves consideration whether this grant program in its current form reflects and supports cost-effective best practices. I introduced H.R. 68, the Juvenile Accountability Block Grant Reauthorization and Bullying Prevention and Intervention Act, in response to the need to reauthorize long-awaited juvenile justice program and to authorize and support funding to state and local governments, but also to have a new vision, not only sanctions that would not reduce recidivism for our young people, but incentives, untying the hands, and in addition, looking at the horrors of bullying. We find out that 1 out of every 4 students, 22%, report being bullied during the school year, but 64% of children who are bullied did not report it, and only 36% reported the bullying. More than half of bullying situations, 57%, stop when a peer intervenes on behalf of the student being bullied, and school-based bullying prevention programs decrease bullying by up to 25%. We want more of that. Research studies have shown that bullying in schools has a devastating effect on victims and perpetrators and the likely path into juvenile or criminal justice system. We realize that what we're doing today may make life for a teen much better. This legislation not only deals with incentives like counseling and other aspects of dealing with a juvenile, restorative justice, but it also takes in the new and advanced cyberbullying, which many students will tell you is the most vicious. Not in the eyes of teachers and fellow students who can stop it, but in the unfortunate comfort level of your bedroom. A child may have an intrusion and may be bullied. And so this is a 21st century, JB. It is a recognition that our young people have changed, technology has changed, and we must change to ensure that we embrace them with a strong hand, but an understanding hand and an ability to compromise to be able to see what is the best pathway for their life. I'd like to thank the staff as well on both sides of the committee. The Republican staff, our staff, Mr. Goodlatte staff, Mr. Sensenbrenner's staff, Mr. Conyers' staff, and certainly I want to make mention of which we will honor in just a moment, my counsel, Tiffany Johnson, who passed away a few months ago. I want to acknowledge my staff in my personal office, Ms. Williams, and our additional fellows and interns who've been so helpful in this matter. Mr. Chairman, I would like to submit these letters to the record at this point because without the advocacy groups giving their constructive thoughts that we could analyze, we would not have a bill that responds to the new approach to taking care of young people. I ask unanimous consent to put into the record a letter signed by the American Psychological Association, Campaign for Youth Justice, Child Welfare League of America, Center for Children on Law and Policy, Juvenile Law Center, Pace Center for Girls, Schubert Center for Child Studies, Southern Poverty Law Center, the Sentencing Project, that is the National Juvenile Justice and Delinquency Prevention Coalition. I ask unanimous consent.
Without objection, they will all be made a part of the record.
A letter from Dr. Robin Jenkins. I ask unanimous consent.
Without objection.
An article saying from the U.S. News and World Report, what youth incarceration costs taxpayers, $21 billion annual. Ask unanimous consent.
Without objection, be made a part of the record.
The National Council of Juvenile and Family Court Justices, which indicates that juvenile court justices should have the same status as the highest level of trial court, and asked for additional ideas of dealing with the individualized and graduated responses, both sanctions and incentives. Ask unanimous consent.
Without objection, they will be made a part of the record.
And finally, Mr. Chairman, a graduated responses toolkit from the Children's Law and Policy Center.
Thank you. Without objection, they will be made a part of the record.
And I simply close my remarks by saying that this is an important step toward our overall goals, looking forward to completing them of criminal justice reform. But I would say that juveniles' lives who have come awry of the law in the early point of their life, when we know that intervention, love, firmness can restore them and put them on a path that we will see them as doctors, lawyers, and astronauts and members of Congress, we know that the thinking in this bill of best practices, evidence, and the opportunity for incentives goes a long way in changing their lives. With that, I ask my colleagues to support the legislation. I yield back.
Chair thanks the gentlewoman. The chair would note for the members of the committee, for those who may not have noticed this, that our friend and colleague and very active member of this committee, Congressman Ted Poe, Judge Poe announced yesterday that he has been diagnosed with leukemia. So we would ask that all of you hold him up in your prayers. He has a statement which you can read and expresses his confidence that he will beat this. And as he would say, that's just the way it is. So keep him in your prayers.
We will.
At this time, I now recognize the ranking member of the Crime, Terrorism, Homeland Security, and Investigation Subcommittee for the purposes of offering an amendment in the nature of a substitute.
Thank you,
Clerk will report the amendment. Members have the amendment in the nature of substitute before them. The clerk will report it.
Amendment in the nature of a substitute to H.R. 68 offered by Ms. Jackson Lee of Texas. Strike all after the enacting
Without
clause.
objection, the amendment in the nature of a substitute is considered as read, and I'll recognize Ms. Jackson Lee to explain the amendment.
Thank you so very much, Mr. Chairman, and allow me, members, to again thank you and go in a summarized statement about this amendment. It's unusual to many on bill, but I'm just grateful for the many who have invested in this. As I indicated, this is a bill to deal with best practices in line with prior reauthorization, articulating the critical importance of funding evidence-based strategies for holding youth accountable, empowering states, and strengthening the juvenile justice system. I've worked previously with our previous member, Congressman Bobby Scott, and I want to thank him as well in the work that he's doing on the Ed and Labor Committee at this time, trying to help our young people. So the reauthorization of this bill provides, again, evidence-based, but it also provides language that provides for graduated sanctions, which are sometimes harsh, and this legislation and the amendment provides language of incentives. The term incentives means individualized, goal-oriented, and graduated responses to youth compliance with court orders and case disposition terms designed to, in fact, reinforce and modify the behavior of the youth offender. Incentives may include certificates of achievement, recommendation letters, family or program activity, meeting or special outing with community leaders, reduced community service hours, extended curfew or home visit, or decreased court appearances or term of court order supervision. It would also mean it gives the family members, parents, grandparents, extended community the opportunity to work with this juvenile in the incentives that may be given. It gives schools the ability to have a little bit more flexibility in assisting this juvenile as well. In particular, a court may put in place counseling, restitution, community service, a fine, restorative justice programs, anything to say to the young person that we're willing to look to you to help us reform your behavior by giving you support systems to make a difference. And so my amendment, hopefully, is driven by all of the work that we've done since the time that I've introduced this bill, which has been a few years ago, but we've had the opportunity to look at this closely, and we believe that we're on the right track with research-based anti-bullying, how best to address it, and then the new phenomenon of cyberbullying to work against that as well, and for the resurgence of gangs, specifically gang prevention, but all of that goes as well as mental health services and trauma-informed practices to ensure that we are able to look at the whole reform of the child and to work with their family and extended community. So I ask my colleagues to support this amendment as it enhances the reauthorization, gives us better tools, and gives us better ways to invest in our young people for whom the future of this country depends upon their success. Thank you, and I yield back.
Chair thanks gentlewoman and recognizes himself in support of the substitute amendment, which reauthorizes the JBAG program for $25 million a year. Grants from this program have helped provide communities with restorative justice programs, police and probation partnerships, drug and teen courts, and other programs which facilitate the successful reentry of juvenile offenders from custody back into the community. In 2013, the Juvenile Accountability Block Grant Program provided local communities in my home state of Virginia with over $386,000 to assist them in their efforts to make families and neighborhoods safer. These federal grants are used to combat gang violence, curb juvenile drug use, and provide mediation services to juvenile offenders and their victims. Meeting the challenge of reducing juvenile crime extends beyond the traditional punitive criminal justice system. One reason why this amendment, in the nature of a substitute, adds graduated incentives to the available purpose areas is to encourage juveniles to conform their behavior to societal norms. This is one more way juveniles in the justice system can receive the support they need to get back on the right track. This amendment also removes available purpose areas for the allocation of JBAG funds, including those best addressed by the states, like the hiring of juvenile court judges, prosecutors, probation officers, and court-appointed defenders and special advocates. It also removes gun courts as an available purpose area for which states may use allocated grant funds. The substitute enhances a purpose area for anti-bullying and anti-cyberbullying prevention programs, as well as mental health services. This amendment also promotes accountability of taxpayer dollars. The goal of the oversight and accountability mechanism in this amendment is to ensure that funds are allocated and used appropriately. Effective grants stem from good governance and strong oversight. Finally, this substitute clarifies through a sense of Congress that best practices should be followed in the administration of all JBAG grants. I urge my colleagues to support this amendment and strengthen juvenile justice programs throughout the country. Are there any amendments to the amendment? The clerk will report the amendment. The chair would point out to the gentlewoman she needs to ask unanimous consent.
Yes, I am.
Without objection, the amendment to the amendment in the nature of substitute will be considered, and the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 68 offered by Ms. Jackson Lee of Texas. Page 1, line 2.
Without objection, the amendment to the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Let me thank you very much, Mr. Chairman, and let me, as I begin, just to emphasize the importance of this legislation. To emphasize the importance of this legislation, let me start as I introduce my amendment with a statistic for all of you, and that is as many as 70 to 80% of youth involved in the justice system meet the criteria for a disability, while at least 75% have experienced traumatic victimization, making them vulnerable to mental health disorders and perceived behavioral noncompliance and misconduct. And so this bill, of course, provides that mental health inclusion to be able to help steer young people who have experienced certain objective issues in their life. I'm very pleased to offer this amendment, and I again thank the chairman and the ranking member for their work with us in particular. Many of you know how hard Tiffany Jocelyn, my counsel who passed away 4 months ago, worked on this legislation. It is legislation that was near and dear to her heart. And so we're very interested in acknowledging the hard work, how dedicated and hardworking, the enthusiasm she had, and the expertise to her work. We miss her dearly, but we continue to benefit from her wise counsel. And she had a strong commitment to the juvenile justice system and brought with it an astuteness and an affection. It may be evidence in the love she had for her family members and her young cousins and her wonderful family who embraced her well. She worked hard to advance this bill and to reform the ways we address youth in our juvenile and criminal justice systems. And so this bill, we would like to have her name as we continue the causes she has championed. This bill would be ultimately, if this amendment was passed, called the Tiffany Jocelyn Juvenile Accountability Block Grant Reauthorization and the Bully Prevention and Intervention Act of 2015, which would in essence provide us with the framework of which we've just discussed. Secondly, this amendment would create a funding offset for the bill by reducing general administration expenditures by the Department of Justice for fiscal years 2018 to 2022. And I understand that this is a way for us to handle this as we move forward. I believe this is an appropriate procedure and process because, again, let me emphasize, we are doing something important today. We're reauthorizing, putting the Judiciary Committee stamp on criminal justice being a part of juvenile justice and juvenile justice being a part of criminal justice. And I would ask my colleagues to support it. Finally, let me say, in the passing of Tiffany, we all felt a great loss. This great tribute to her will be a lasting tribute and salute to her and her family. And I want to acknowledge that her father, Mr. Jocelyn, is listening to our debate. And I want to thank him for his beautiful daughter and to all of his family for how she contributed to the betterment of this country. With that, I ask my colleagues to support this amendment to the nature of a substitute, amendment in nature of a substitute.
Thank you, Chair. Thanks the gentlewoman, and recognizes himself. I thank the gentlelady for her amendment and support, ensuring that this bill complies with all necessary offset rules that promote good stewardship of taxpayer dollars. I would also like to recall Tiffany Joslyn's dedication to juvenile justice issues. Tiffany was a passionate and strong advocate for juvenile justice, and while her counsel and friendship is missed on the committee, it is appropriate to name this bill after a public servant who devoted her energy and legal skills toward these important issues, and I urge my colleagues to support the amendment. For purpose, the gentleman from Michigan seek recognition.
Strike the requisite number of words, Mr. Chairman.
Gentleman is recognized for 5 minutes.
My fellow colleagues on the committee, it's fitting that through this amendment, we're naming the bill in honor of Tiffany Joslyn, who was a dedicated staffer working primarily with the gentlelady from Texas who has worked on this legislation. We sadly lost Tiffany Joslyn in a tragic motor vehicle accident in March, but we vow to redouble our efforts on the issues that were her passion, particularly youth justice reform and criminal justice reform. And so I am pleased to urge support of the amendment to the substitute and urge that we pass this with all deliberate speed. Thank you, Mr. Chairman, and I yield back the balance of my time.
Mr. Chairman, would the gentleman yield?
Yield to the gentlelady from Texas.
Let me thank all of you for your very kind words about Tiffany. I think when you have bipartisan recognition of the great service that she's given, and all of the members realize how important our staff expertise is to all of us, and certainly contributing to the legislative process of this Congress. Thank you so very much for honoring her with this tribute, giving her the ability, of course, to have long-lasting presence on something very important and near and dear to her and near and dear to us, reforming the criminal justice system and reforming it starting at the very roots, and that is helping our young people steer away from the criminal justice system. With that, I would like to put into the record, Mr. Chairman, the mentor letter from the Mentor National Mentoring Partnership, and a letter in support of this legislation, which is a tribute to what we are doing, from David Shapiro, the Chief Executive Officer. I'd ask unanimous consent to put that into the record and ask my colleagues to support naming this legislation after Tiffany Joslyn, and as well making sure that we have the funding process that we should have for that. Again, it will be named the Tiffany Joslyn Juvenile Accountability Block Grant Reauthorization and the Bullying Prevention and Intervention Act of 2016, excuse me. Thank you.
Without objection, the document will be made a part of the record.
Mr. Chairman, I yield back any time of mine that may be remaining.
Chair thanks the gentleman. Question occurs on the amendment to the amendment in the nature of substitute. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the ayes have it, and the amendment is agreed to. Are there any other amendments to the amendment in the nature of a substitute? The question is on the amendment to the, question is on the amendment in the nature of a substitute to H.R. 68. All those in favor respond by saying aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 68 as amended favorably to the House. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the bill as amended is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all our members for attending. The markup is adjourned.
Thank you, Mr. Chairman.
This was Sheila Jackson.
Been a long time.